All right, good morning, everyone. Thank you again for joining our MedCom desktop discussions. My name is Casey Hope. I'm the marketing manager at MedCom Benefit Solutions, and I am joined again today by the wonderful Michelle Barkey, our senior legal counsel at MedCom Benefit Solutions. Good morning, Michelle.
Good morning, Casey.
Thanks for being here today. We had some stuff happen at the end of last week with COBRA, didn't we?
We did.
So I want to just mention real quick, there's been a lot of questions come in about the COBRA and coronavirus information that came out at the end of last week. Michelle and I will be hosting an informational webinar on Thursday afternoon at 2 p.m. Eastern Time. You are able to register for that webinar by going to at MedCom Benefit Solutions on LinkedIn. You can find that link there. We shared it on Friday. And I will also, once this desktop discussion is concluded and I send out the complete questions and answers, I will go ahead and send that registration link to the group, just in case you're not already registered for that webinar, where we're going to talk about COBRA and the coronavirus and everything that kind of happened at the end of last week. I know Michelle has been working tirelessly to kind of get caught up on everything that's happened. So we appreciate that very much. And we have a couple of questions about it today where we'll start to get in, but really you'll be able to find that information on Thursday if you can join us for that webinar. All right, Michelle, are you ready to get started with this week's desktop discussion questions?
I am, Casey.
Excellent. Okay, our first question today. A group's FSA plan year ends on 6/30/2020, and they have a 60-day run-out period to submit expenses incurred by 6/30/2020. They have a $500 carryover, not the grace period. I know we can amend the plan to allow for up to a 90-day run-out period, but that doesn't solve the problem of being able to incur expenses. The group does not want to amend the policy to allow for a grace period when they would lose out on the carryover. Can you please confirm if there are any other options the plan can consider at this time?
Thank you for that very interesting question, Casey. And I want to start out with part of the changes that happened last week does affect the run-out period. So they will not need to expand the run-out period, as we do have a new quote unquote breakout period, and it's going to assist with this. It is supposed to be in place for all cafeteria plans that have claim filing deadlines, and that includes the FSA that has a run-out period. Basically, under this new breakout period, the period between March the 1st of 2020 and 60 days past the end of the national emergency. And the national emergency is still going on, so we don't know when the 60 days is going to start running. This period is now told or carved out, and the run-out period would not commence until after that. So again, we still have the national emergency. It's still in effect, and 60 days past its effective date, the run-out doesn't even start. This is new, and it affects COBRA, and it also affects special enrollment rights as well. And that's what our webinar on Thursday is going to be about. Now, that being said, when plans are a non-calendar year plan, they are having a real hard time this year because we know that non-elective surgeries were postponed, and even if they're going to get back up and running, a lot of people will not be able to have what they need to have done before the end of the non-calendar year plan, as in this case, 6/30. That being said, at this point, there is still very little in the way of assistance for the FSA, and it is truly hurting those clients, especially those on a non-calendar year plan. There are some that say you can make a change in the FSA whenever there's a change in the healthcare need, but I have not seen any documentation from the IRS that supports that. And MedCom Benefit Solutions, after a thorough review, does not believe that this is supported by the current regulations. Others believe that there might be an argument that there is an increase or decrease in the cost of coverage would allow for a mid-year election change. But again, the FSA is stable. You choose the election at the beginning of the plan year, and there's no real cost change to it. So we do not believe that you can make a cost change mid-year on an FSA. So the question comes out is that our belief is that it's purely a belief, is that the federal agencies are so overwhelmed and necessarily focused on other priorities. And again, we just had the breakout period this week. And consequently, the technicalities pertaining to the FSA are simply not on their radar at this point. Hopefully they will be in the near future. We have asked the IRS on several occasions to go and look at it. That being said, based on all the actions of our federal government during the onset of this pandemic, we believe that common sense flexibility is the acceptable course of action in light of the COVID-19 pandemic. There's always going to be some risk, but we believe 2020 will be the year of forgiveness and discretionary enforcement. Casey?
Thank you, Michelle. We have another question about FSAs. I'm glad to have those kind of back to back. When FSA funds are forfeited at the end of a plan year back to the employer, could the employer disperse funds back to the employees according to who lost out on their FSA funds due to not utilizing their FSA, or would they have to be distributed evenly to all plan participants?
You know, unfortunately now, according to the regulations, they have to be dispersed evenly to all plan participants or used for administrative purposes for the following year's FSA. However, we do believe that there will be, as we talked about in the previous question, that discretionary enforcement, but we can't guarantee it. You know, this would be kind of like a bending of the rule, and any employer that changes to bend the rules, to be fair and equitable to their employees, they should be prepared to document and to demonstrate that all the actions they were taken were in the best interest of the participants, especially in light of the coronavirus, where nobody could expect the impact that it would have on non-calendar year plans. They certainly wouldn't they should also document that they were not trying to circumvent the payment of owed taxes, and that they did it in a fair and non-discriminatory way, i.e. they gave it back to the plan participants who actually were not able to spend their money in the way that they had wanted to, and that this was reasonable. This will always help ensure the best possible outcome of success, although no guarantee, in the event that there is a complaint or the IRS challenges the employer's decision. Again, we believe this year is going to be one, as a lot of the agencies have indicated, discretionary enforcement, but we cannot in good faith say that, yeah, go ahead and do this. But again, document what you're doing, the reason that you're doing it, and that you're not trying to break the IRS rules, but you believe that this is in the best interest of the participants.
Thank you. If an employee is laid off due to COVID-19 and must go on COBRA to continue their health insurance, is there any premium assistance available?
And again, Casey, thank you for advising everybody that we are going to be having a webinar on Thursday. At this stage, there is no premium assistance like the American Recovery and Reinvestment Act for ARA. As you remember, after the last financial crisis in 2009, there were some premium breaks for COBRA participants. But now we do have the breakout period. And as I mentioned before, it specifically is for COBRA participants as well as for run-out periods and for special enrollment rights. But basically, between March 1st and 60 days past the end of the national emergency, all requirements are basically told. And the employee then has 60 days to decide whether or not to elect COBRA. So if the national emergency ends on May 31st, 60 days past that, still in the tolling period, and then 60 days past that, they get to decide whether or not to elect COBRA. And then they have an additional 45 days to pay. So we could be going into October for actual payment. As mentioned, we are doing that webinar on Thursday. The other thing I always want to clarify is that by laid off, you mean terminated and not expected to return to work. This would be a qualifying event. If you were furloughed, unless your plan document says furloughed employees are terminated, it would not be a COBRA qualifying event, and COBRA would not attach. I also always want to make sure that people understand that if you do reasonably expect these employees to return to work and they are furloughed and you are an applicable large employer, then the ACA also is applied. And if somebody is in a stability period following a look-back measurement period, or had been a full-time employee and had not gone through a waiting period of more than 90 days, then for the next 3 months, you have to continue the benefit. So just don't forget that if you're an applicable large employer, ACA still attaches. Know the difference between laid off, which means you're not expected to return to work and you're basically terminated, as opposed to a furlough where you might come back to work, and as long as you're on the books, the ACA still attaches. Now, again, join us on Thursday because this breakout period also applies to those currently on COBRA, and now they have a period of time not to pay their premiums. So that between March 1st and 60 days past the breakout, past the end of the national emergency, then they don't have to pay their premiums until the 30-day grace period expires after that. So the challenge is going to be holding the claims in abeyance pending receipt of all the back COBRA premiums. The insurance companies don't have to pay the claims during that period of time, but it's becoming a little bit of an administrative logistical nightmare as how do you advise the insurance carriers as to those who are in abeyance and have not paid their premiums during this breakout period, because it's not something that's normally in the COBRA repertoire. So again, there's going to have to be a lot of administrative decisions made on how that is handled.
Yes, all of this is incredibly complicated and very confusing. There's a lot of different aspects involved. This question that we have next is no different. Just bear with me. It's a long question, but we'll do our best to ask and cover it the best way possible. What will happen if someone elects COBRA and they are reinstated with the benefit carriers and then never makes their COBRA payment? If they are utilizing the plan, claims will be paid for terminated employees that may never pay for COBRA coverage. Those claims will impact the employer's premium versus claims loss ratio. Can the carrier deny previously paid claims and obtain funds back from the providers they paid so the claims fall off employer's liability? Will the employer be reimbursed for the premium they have paid to the insurance carrier for that individual's COBRA coverage? Right now, carriers have strict rules regarding retro premium credits. They will typically only go back 60 days. Does this create a loophole where people can obtain free health insurance?
You know, under the old COBRA rules, the carriers typically did not reinstate someone until after the premiums were paid. They would always look to see that 60 days, whether the election notice was actually signed within the 60 days to determine whether or not they were eligible for COBRA. It was always part of their administrative process. And then after that, when the individual had the 45 days to pay the claims, to elect, to pay the premiums, that is when the carriers would typically reinstate the benefit and they would pay it. With this breakout period, it's going to be a mess to start with. The insurance carriers do not have to pay claims during the breakout period until the premiums are actually going to be paid. How this is going to be happening administratively is going to be something that is going to have to be worked on. could they technically go back to the providers and get the reimbursement if the person never paid the premiums? And the answer would be yes, they could go back and say it was an overpayment, but that is always pay and chase, and that's a hard game. We used to do that back when MedCom was a third-party administrator, and paying and chasing is never a great philosophy. So it is going to be difficult, but in the normal course of COBRA, typically the carriers would look to see whether or not the election was made in 60 days and the premium was made in 45 days before reinstating. But this new breakout period is going to be a real challenge.
Thanks, Michelle. Due to changes to COBRA for COVID-19, there is a lot of confusion on whether coverage can or cannot be suspended during the pandemic if someone has made at least one payment. It appears they don't have to make further payments until after the pandemic. Can you clarify this?
Yes, and again, as we've talked about, this was something new that came out last week. Now, there had been some states like Ohio that had actually held the premiums in abeyance and said you didn't have to pay your COBRA premiums. But up until last week, when the government came out with this breakout period, where again, from March 1st to 60 days past the pandemic, and then following the grace period after that for those that are on ongoing COBRA, premiums do not have to be paid. And you can suspend the COBRA, you can suspend the coverage during that period of time, and then they would be reinstated. And again, stay tuned for our seminar on Thursday at 2, because there have been a lot of changes. And this breakout period affects COBRA. As we discussed, it also affects run-out periods because we've got a tolling now for when claims are actually due. So even for the insurance carriers, if they say we have to have a claim in within, typically it was a year, you have to submit all the claims. Now that 365 days is actually tolled by this breakout period. And it's also going to be tolling special enrollment rights. So if a baby was born on March 1st and they had 30 days to elect the coverage, and then by April 15th, they hadn't elected the coverage. Well, guess what? Now they're in a breakout period, and we have to go back and say that they have until 60 days past the pandemic to exercise their special enrollment rights. So a lot of things to talk about on Thursday, but I hope that this has been helpful.
Michelle, we had one extra question submitted, and we'll do our best, as I've said before, to answer it. Are health insurance premiums included in quote-unquote payroll costs when determining the amount of a PPP loan that is forgiven?
Yes, you can include the healthcare premiums in the PPP loan as part of the costs.
Excellent, thank you. So that's all of our questions that we have today. But as I've said, we are going to address so much more about the COBRA changes on Thursday. We'll go into a lot more detail and be able to provide a lot of information for you guys that will hopefully clarify some of these really confusing questions surrounding everything that's changed. You can find that information once again at MedCom Benefit Solutions on LinkedIn. We are also going to email out the complete questions and answers from today, and I will include the registration link to you, so you will also be able to have that. If you did not get our email last week, I just want to remind everyone that our desktop discussions are now on Tuesdays at 10 a.m. only, because of some things that have come up with COBRA and having to present some webinars and things like that. We have kind of paused having them on Thursdays as well. If we see the need, of course, we are here to answer the questions and we'll let you know. But as of right now, our desktop discussions will continue on Tuesdays at 10 a.m. So please still feel free to submit those questions to COVID-19 questions at medcombenefits.com. Michelle, thank you so much for the information you're giving today, and thank you so much for the information that you were preparing for us on Thursday.
And thank you, Casey, for arranging all this.
Absolutely. I'm glad to be here, happy to be of help. Please reach out to us if you have any further questions. If not, we will kind of quote unquote see you on Thursday at our webinar at 2 o'clock Eastern Time. Thank you all so much and have a wonderful rest of your day.